Hello, my name is Oscar Kazen, and it's my privilege to work with the Kazen Center as it relates to an innovative and exciting new opportunity to assist individuals who are going through some of the toughest crises and mental health illnesses that we know of. It's the individuals that we see each and every day who are suffering from such a depth of mental illness that they themselves cannot even become aware of the fact that they're ill. It's the one that we as judges know that you wish to reach out and do something. Change their lives, get it fixed, and we can't. So what do we do with those individuals? Well, fortunately, in recent years, the thought that a court with its power and authority can come and use its ability and its resources to help those individuals in our communities who are suffering with these significant mental health illnesses and somehow help them get to a point where wellness becomes their habit rather than illness. It is that thought, that ability of a judge to put on his robe and do more than bang the gavel and sentence someone, but instead use that robe, use the effect of that robe upon those individuals who are suffering to take their meds, to cooperate in treatment, to understand that there is a better route, that illness doesn't have to be their entire lives. And that's where AOT comes in, assisted outpatient treatment. You can call it what you wish. Every judge is slightly different. Some people call it involuntary outpatient commitment. Some people call it court-ordered treatment. But I prefer, and many of us prefer, assisted outpatient treatment, because in the end, what we as judges do with these individuals who are ill is work together. First, it takes a judge and his staff or her staff with a desire to get involved in a person's life to the extent that they can, ethically, and change their patterns. And it takes a judge who's willing to think outside the box. There's an opportunity for us as judges to make a difference in people's lives, more than we traditionally do. We don't just bang the gavel, we don't just issue orders, but we actually get involved in ensuring that an individual who is suffering from serious mental illness has an avenue, a road, somewhere to walk hand in hand with a system that often ignores them. Many jurisdictions have what is referred to as a drug court. Now, in the old days, we as judges used to remember that drug courts were basically a fancy docket, a place to send individuals so that we could speed them along with their conviction and on into jail, usually in the smaller of the drug offices. They were rocket dockets for drug offenders. Somewhere, though, however, in the late 90s, we began to think outside the box as it related to drug courts. And that is, what happens if we make treatment the goal rather than punishment? Well, I don't have to reinvent the history for us as judges as it relates to drug courts. We now know that almost every jurisdiction across the country has a therapeutic drug court where the patient works together with the judge and some sanctions when necessary to sober the individual up and make wellness their habit. And it works. It's now become a best practice. We now know that our jurisdictions cannot survive and cannot make an impact without these therapeutic drug courts. Well, there's another route for mental illness. Traditionally, as a judge over the years, I had been accustomed to simply sending someone away to an involuntary inpatient commitment. We've got to do better than that, because there are those individuals who, although they are in inpatient treatment, can benefit from outpatient treatment. But how do we keep them on their meds? How do we convince an individual who has historically and through their lives said, I'm not ill, I don't want to take meds, to take their meds? Well, as it turns out, and I'm going to share an old joke with you, there's an individual who gets a flat tire just outside our state hospital. And as he's changing the tire, four of the little takes off the lug nuts, and he goes to put the tire back on, and he can't find the four lug nuts. Well, across the way and through the chain link fence is a patient who yells out and says, hey, why don't you take one lug nut off of each of the other 3 tires, and that way you'll have 3 lug nuts in each tire, you can make it home. And the guy turns around and says, man, how's such a smart guy like you make it into a place like this? His answer, I might be ill, but I'm not stupid. And that's the first step in an AOT. These individuals may be ill, and illness may be their pattern, but they're not stupid. And our experience is that when you put them in front of an authority figure who initially has to show some authority, but thereafter shows that they care and wants to bring them onto a path of wellness, these individuals develop trust. These individuals develop understanding. And these individuals, whether or not it's simply for fear of a consequence that may never happen, that is rehospitalization, listen. And it turns out in about 80% of our cases, we had great success. So when you take the power of a judge and the effect of the robe, we tend to say the black robe effect, and place that before any individual, people listen. Mentally ill people listen. And it gives you that little crack in the window where you might be able to gain trust. And you might be able to get them to listen to their caseworker. If it means the judge has got to be the bad guy, be the bad guy. If it means the judge has to hug the individual, shake his hand, encourage him, motivate him, see him once a week if necessary, simply ask, what do you need? Be that person. It makes a difference in their lives. You know, the black robe effect, that term that we coined, honestly isn't anything other than our ability as judges to speak in slightly louder voices. Now, we know that whatever we say on occasion has a greater impact. You know, as a judge in the past, when I was sitting on the bench, I always knew that whatever I said echoed and reverberated slightly larger because I was that judge. Now, I've been on the bench and off the bench, and it's interesting that we as judges will find that our jokes are a little bit funnier when we're a judge and a little less funnier when we're not. It's the black robe effect. People listen to us a little longer when they probably have to get somewhere because we're a judge than when we aren't. We can use that same effect on individuals who are mentally ill. And if we can keep them under medications just long enough to clear up, we can make that difference. And that's, in essence, what AOT is. It's a judge making sure that he gets into the life of an individual, works with him so that they can avoid a perceived consequence, and that's typically rehospitalization. I mean, they don't want to be in the hospital any more than we do. And working together with them to give them that window of opportunity where the meds or whatever the treatment is takes effect so that wellness becomes their lives. The black robe effect, again, that term that we coined, isn't the entirety of what we do. I mean, to be honest with you, we as judges are simply the tool to get their attention. But we have to pay respect to the individuals who are also in the room, who are also working with the patient. I've learned that over the years, if you become that judge who wants to come in and take control of AOT, it will fail. You have to recognize that the other individuals in the room, that is the treatment professionals, an ACT team, an assertive community treatment team, if that's what you have in your community, or that physician, or that doctor, or that licensed care worker, know more about mental illness underneath one fingernail than we have in the entirety of our repertoire. We are pretty good at getting elected, and we're pretty good at being judges. If we weren't, we wouldn't still be there, I guess. All of us share that in common, but we aren't doctors. We might play one on TV, but we're not doctors, and we're not care workers, and we don't know. They do. And the essential part of an AOT team, the essential part of making the black robe effect work, is having a team around you that you rely on. You ultimately become the voice in the room. You're ultimately the one that tells the patient, this is what I want to see, I hope we can get there, why did you do that, why didn't you do that, good job with doing this or that. But all of it, no matter what we do, should be based upon the advice that we're given by the members of the team. The team, at least in San Antonio, typically was comprised of licensed professional workers who were members of an assertive community treatment team. We focused and we tried as hard as we could until we finally did get all the patients to be seen by one of the doctors, so we centralized the approach to treatment. So one ACT team serving one court who funneled and worked with one or two doctors on all the AOT patients. So if you can do that in your community, it does work the best. However, listening to your team probably is the most important factor in a successful AOT. You're just the voice. You're the tool. You're their bad guy. You're their good guy. But you ultimately have to ask them. If you've ever watched a therapeutic court, the essentials of a therapeutic court require that you staff each and every individual before you see them. Some judges find it much more efficient to staff, and that is discuss with the team what the approach for the day will be with this patient before the patient comes in. Some judges will do all the staffing before you begin the court session. And again, there aren't any hard and fast rules. In AOT, you do get the opportunity to create the court that works best for your jurisdiction. I personally always found it best to staff right before the patient came in. So we'd take a quick break before we brought each patient into the room to speak to them about their progress and their treatment plan. I found that was the most efficient thing because inevitably, if you staffed 10 or 15 or 20 people before the day began, you'd be doing it again before they walked into the room anyway. So that's one of the things that you can do to make your interaction with the patient best. But that's your opportunity to hear what it is the treatment team is recommending. Sometimes the treatment team will say, look, Judge, he's skipping his meds every other day, and you're going to have to be a little tough on him. And that's when you put your hat on, and as a judge, as the creative, talented individual that you are, or you wouldn't be there, to look him in the eye and say, Jimmy, I understand you didn't take your meds. Last time that happened, you know what I had to do. We had to wait, and you got sick, and we had to take you to the hospital, and the sheriffs had to go get you. You really want that to happen again? You know it's going to happen. You know I'm going to do it. Or will you work with me? Will you let's try taking our meds for 1 week and see how that works. There's a lot of negotiation that does occur between the judge and the patient. Again, we are not a criminal court. The beauty of a criminal court is that you have the ultimate sanction, and that is the deprivation of freedom. An AOT in many ways is much tougher. It requires you to be creative. It requires you to remind them of the consequence they most seek to avoid, rehospitalization. But we can't force them to take their medication. We can't threaten to detain them just because. But they aren't foolish. They understand the consequences. If you have a patient on AOT who simply ignores the consequences, just doesn't care about being taken in and being detained, perhaps that's an individual you don't want on AOT. Not everyone is going to make it to AOT. In the criminal court system, we have been very successful at developing mental health courts. And those judges, along with the movement in AOT, have recently developed a system where, we bring people in, we use that same black robe effect to keep them engaged, make sure they understand their consequences, make sure they're attentive to their probation officer or their treatment giver or their caregiver. However, criminal courts, to be honest with you, have it made. I've been a criminal court judge in the past. It's pretty easy to look at someone and say, well, Jim, you don't take your meds and you violate the conditions of your probation, you got to go to jail. That's an eye-opener. And as a criminal court judge, in many ways, asking a person to comply with a treatment plan is a much easier thing. What we speak to in AOT is the ability of typically a probate judge or a mental health judge on the civil side of the courthouse to ask someone to take their meds. And there's some ground rules. We can't just arrest someone because they won't take their meds. We can't tell someone, if you don't want to take your meds, we're going to strap you down and put a needle in your arm. That's not what we're about. Now, certainly there is a consequence. If an individual decides not to take their medications and they deteriorate, you and I in the past, and you must act. And if they become, in most jurisdictions, the threshold is a danger to self or others, or are so gravely disabled that they cannot maintain themselves, we act as judges and we take them into the inpatient setting. And that usually requires law enforcement, and it usually requires a doctor's certificate and a doctor's commitment and an involuntary stay at some facility. Those four things in and of themselves are not strange to the patient. They're aware of it. They've been through it. And by the way, if you're dealing with someone on AOT who has never experienced those things, you have the wrong person on AOT. AOT is designed for the individual who does become a danger to self or others, an individual who does become gravely disabled to the extent that they can't take care of their own affairs. It isn't designed for the individual who is having some problems for the very first time. And we certainly want to be sure that when we talk about assisted outpatient treatment in general and in public, we want to be sure that we delineate and separate that difference. We are not a threat to individuals who are mentally ill. It's a sad consequence and reality in life, but people get ill. However, in our country, if an individual isn't a danger to self, isn't a danger to others, and isn't so gravely disabled that they can't provide for themselves, they have every right to be mentally ill, and they have every right not to take their medication. We step in when the other three situations occur, and that's an important distinction. So if you are an AOT judge on the civil side, unlike that criminal court we talked about, it's a tougher road. You've got to have a lot of talent to work with these people. You need to be prepared for that. You need to be the type of judge that knows you're going to engage with the patient. You're going to motivate. And as I said in the past, if you've got to yell, you yell. If you've got to cry, you cry. If you've got to hug, you hug. If you've got to clap, you clap. But you work with the individual, and the goal is to get that individual to get to the point that wellness has become the habit. AOT should be used in those circumstances where individuals can't recognize their illness or won't recognize their illness and repeatedly become that danger to self or others. It shouldn't be used in an ad hoc manner where just anybody who's ill goes before the judge and gets placed on outpatient treatment. That's an important distinction that you mustn't forget. We all know that judge who wants to do the cutting edge thing. They want to do something because no one's done it before. And when you think about it, back in the 90s, there were some judges, many of us, who bothered to be trained in therapeutic drug courts. And in those days, the motivating factor was that we were running out of jail space and prison space, and we were trying to figure out a way not to have individuals with drug offenses basically fill up the jails and our prisons where more egregious offenders should be held. And the thought that treatment would work better than sanctioning seemed to work. And it was the motivating factor. And a lot of judges stood up and said, you know what, I want to be that judge. And there is that judge who wants to do it because no one else has done it. Ask yourself, in my jurisdiction, is there an assisted outpatient treatment court? Do I want to be the individual that plows through the ice, that, shapes the field? And if you are, I suggest to you that in and of itself is a reason for you to consider AOT. You can't walk down the hall anymore in Bexar County, in San Antonio, in Texas, without finding a therapeutic drug court. We've got a misdemeanor drug court, we've got a felony drug court, now we've got a misdemeanor DWI and felony DWI courts, we've got prostitution courts. We have therapeutic courts that make a difference. But they started with one or two judges in the day who sat back and said, I understand that there's another way. I understand that someone's got to figure out how to help rather than punish. We're at that same point with mental health. We aren't building big facilities anymore. Our hospitals are deteriorating in terms of capacity. And more likely than not, the illest of the individuals in your community get their mental health treatment either in an emergency room for a few days or the jail. And if you're going to do it at all, one, do it because it hasn't been done before. But two, do it because it's the right thing to do. Do it because it's the future of your community. I mean, what's going to happen 10 years from now? We're either going to have to develop a mechanism where the courts can use their authority where justified to help individuals stay on their treatment plan, motivate them, get them there, get them to take their meds, get them to listen, understand the consequences to their lives when they become ill. or we're going to allow them to deteriorate and our criminal justice system will see them. And then they'll receive, as I said earlier, treatment in the second largest facilities besides hospital in every jurisdiction that I know of, the jail or the prison system. And that is the shame. That is a shame when we as judges know that we could do something about it with extra effort and with a proven method of court's involvement to help these people so they don't get to jail. Then there's a third reason to do something: money. And money is an important motivator in many jurisdictions, or at least the lack thereof. Let me give you an example in Bexar County. When we first took the assisted outpatient treatment court orders and modified them so they reflected a therapeutic drug court, and that is that a judge such as myself was active in participation and supervision of the individuals who were supposed to be on a treatment plan, we looked for the individuals who were the illest in our community. And as an example, in the first year, 2, 3, 4 of the program, we began to study what our effect was. We picked 100 people at random, and let me tell you how ill they were. Of those 100 people, they accounted for 67,000 plus lifetime beds. We were able to track the usage based on their insurance, based on the community resources, based on the community hospital stats. We happen to be a jurisdiction that has a state hospital within our city limits. 67,000 bed days. Do you know how ill you have to be to account for 67,000 plus bed days in the community? So we looked at these people, and when we zoomed down into the year, and we looked at those 100 people. In the year before the assisted outpatient treatment and the court order and the court's involvement, they accounted for 164 admissions, 8,873 bed days, 164 admissions, and well over almost 9,000 bed days worth of service to our community. And we know, those of us who have dealt with this, that the most ill, those with the deepest mental illnesses, the most significant mental illnesses, pretty much have the same hospital utilization rates over time. They go through the cycle of illness and poverty and either arrest or detention. And if you really look at their numbers, they kind of stay the same. So these individuals, these 100 people with 164 admissions and 8,873 bed days were placed on a program. In the year of AOT, where we wrapped an assertive team, a doctor, a judge, an attorney, caseworkers, and actively interacted with them, we cut those 164 admissions to 61 admissions. We cut their bed day utilization within the first year almost in half, from 8,000 plus bed days to 4,577 bed days. Now, the more impressive number is this one. In the year after those 100 individuals had gone through the outpatient treatment program, those same 100 who accounted for 164 admissions and then dropped in half to 61, in the year after we were done, after wellness was their habit, they accounted for 38 admissions and only 3,418 bed days. So I mean, you can do the numbers. If you go from the first 8,873 bed days and then subtract the 4,500 plus and the 3,400 plus, I mean, the numbers are this. In those 2 years, the year they were on and the year after, they accounted for 9,758 less bed days. Now, I don't know what jurisdiction you're in, but if you ask most jurisdiction, a conservative number for a bed day cost is about $500. So 9,700 plus bed days times 500, it's about $4.8 million. Now, that isn't money that magically appeared, but what could your community have done if they hadn't had to have spent that $4.8 million on the same individuals that we see coming in and out of our hospitals every single week? How much more progress could we have done? Hence the reason that AOT is a best practice. So if you're not going to do it because you want to be the first guy to do it in your community, and you're not going to do it because it's the right thing to do in changing lives, do it because it saves money. Do it because at the end of 2 years, you can take these same numbers and show the people that be, the powers that be, that it's a worthwhile program that frees up more money for other services. Oftentimes, people will argue as against AOT and try to tell you that, why are you putting people in a program that aren't dangerous to self, dangerous to others, or gravely disabled? Well, first of all, we're not. You're putting individuals who are proven to become dangerous to self, dangerous to others, or gravely disabled without their medication, who have proven that they're not going to take their medication and who don't take their medication, and who have proven that unless we step in, we can help. And so they'll tell you, why should we put individuals who aren't gravely disabled, dangerous to self or others, et cetera, on this court-ordered program? And they'll tell you, what if we could spend that money on treatment? Well, the best ways to fix a building is to attend to the broken windows first. And imagine what our community did or didn't do, could have done, with $4.8 million, what your community could do if that was freed up all of a sudden. We know that most individuals who are ill will wind up in a hospital. That emergency room bed doesn't care if it's an individual with a broken mind or a broken bone. If it's an individual who is schizophrenic and isn't taking their medication, or your daughter or son who just drowned in a swimming pool, or your husband or grandfather who just had a heart attack. If that bed is full, that bed is full. And I suggest to you that we, in the criminal justice system, in the civil justice system as well as the criminal justice system, can step in and work together with the medical system and medical professionals to walk down another avenue. One of the things that we as judges need to be aware of is that there isn't really any hard and fast rules. There isn't the guardian of AOT that's going to come down and say, you should have turned left instead of right. We work within each state's statutory scheme as to how we place an individual on an assisted outpatient treatment. Once you get past how you do it, and that is getting them onto the program, I guess you have to start thinking in terms of what works for you. My suggestion for you is that before you even begin AOT, you sit down with the stakeholders. Again, understanding that you're just one part of it. We as judges love to be in charge. In a way, that's what we're supposed to be doing. We're the authority figure. And it's why, the black robe effect works. But when it comes to setting up the AOT, when it comes to sitting at the table with other professionals, we have to set our ego aside. There is just as important an effect to the black robe effect that I entitled the white robe effect. Think about this. When was the last time you sat in your doctor's office and didn't listen? Now, you may not follow his advice, but you listened to the doctor. You didn't ignore the doctor. You didn't set the doctor's opinion aside because he's the doctor. And there's something about that white robe that has its own effect, that authority. And when you get a judge who's grabbed an individual's attention to the point that the individual is willing to at least follow the rules for some time, and a doctor who's willing to provide the care, knowledge, expertise, and guidance for that same individual, if you combine the black robe effect with the white robe effect, you will have an unstoppable force. It's something that seldom happens. Two of the authority figures come together on the behalf of an individual who's very ill. But it requires that we set our egos aside. Doctors often, the joke is as they walk, thunder is heard through the halls of the hospital, and as a judge bangs his gavel, thunder is heard outside the courthouse. These two gods of thunder need to set it aside. And you need to sit down with the medical professionals and ask, what works best for you? This is what I as a judge bring to the table. Here's how I can make my program work. I can commit to seeing them once a week, once a month. I can commit to seeing them every other day. Whatever works for you. I can commit to monitoring my team. How do we develop lines of communication with the doctor and the caseworkers and the caregivers so that together we develop a plan when we staff that best addresses that individual's needs. You'd be surprised, through the years that I had done outpatient treatment, something as simple as he didn't have his license, so he couldn't go cash his check to pay his apartment rent. Something as simple as that often led to the individual going off track, failing to take his medications, arrested, and in some cases, tragically death. We'll never be able to quantify all the lives we were able to change just by doing those small things. But when you get the power of the court ensuring that these things get done on behalf of the patient, and you get the power and good grace of the medical profession ensuring that it's done appropriately, as I told you earlier when we discussed statistics, it makes a difference. It changes people's lives. So I guess the point of it is, before you set up an AOT, make sure that you sit down with the individuals who are providing the service with a view to an equal voice. Make sure you sit down with your local mental health authority and provider with a view towards an equal voice. Make sure you sit down with the team that you'll be working with a view towards an equal voice. Second point, you have to learn to speak their language. One of the most interesting aspects of setting up the AOT in San Antonio was that I, as a judge, coming into this as a former drug court judge, as a former criminal court judge, you'd be surprised. What you say goes. A probation officer will do exactly what you ask them to do. You're the judge. Not so much when you're dealing with doctors and hospitals. And I think that we need to learn each other's languages. We need to be sure that the doctors understand that we're not there to tell them what their job is. We do be sure that we get to learn their language. And equally, we have a responsibility to teach them our language, that there are some consequences that need to be enforced, not only to the patient, but for those who lack to give the proper care, not necessarily the doctors, but the system itself. I encourage each and every judge not to be overwhelmed by the thought of AOT. I was fortunate when I first started working with the probate courts in Bexar County, when I was working with in the mental health field, to have a mentor, Polly Jackson Spencer. She was the senior probate judge. And her thought was, we can't do it all at once, but nothing stops us from trying it with one person. And if it fails miserably, learn from it and do it again with number 2. And if that fails, make sure number 3 doesn't fail as bad, and number 4 fails a little less. And before you know it, you have a system, a court, which becomes the national model. In San Antonio, we went from having one small court with 1 or 2 or 3 individuals and one caseworker who would kind of chase around and report back to us, to a full-fledged therapeutic court, one where a judge would monitor the individuals as they're placed on the program, where the patient would see the judge the following day, where we, as the court, would see the patient at least once a week and graduate them through the program so that they saw the court less and less as they were doing better and better. But we started off small. And there isn't any reason that you as a judge can't say, let's try this AOT thing. I've got a caseworker who's willing to do it. I've got a doctor who's willing to try it. I have the authority to place one person on a court order. Let's see if we can't get this person to visit with me once a week. Let's see what getting to know what the needs of that individual are can't do for that individual. So I encourage you to do what San Antonio did. We started off with just a couple and wound up with a program where on average we had 80 to 100 people at one point. You can do it too. I often like to say that Bexar County is a 10-year overnight success. And there isn't any reason you can't if you set your mind to it. Don't be overwhelmed by the thought of it. You don't have to start off with a court ready to go. Try one person. Make a difference in one person's life. You'd be surprised how easy it is in the mental health field to make a difference in 2 and 3 and 10 and 20 and 100 and 1,000 people's lives. I motivate you and encourage you to do that.
Hi, Hi, my name's Brian Stettin. I'm an attorney and the policy director for an organization called the Treatment Advocacy Center based in Arlington, Virginia. We are a legal advocacy group that works around the country to remove legal barriers to the treatment of severe mental illness. The area of assisted outpatient treatment, or as it's known in Wyoming, directed outpatient commitment, DOC, has been a major focus of ours since our founding in 1998. We have become, in addition to being very helpful to many states in drafting their DOC/AOT laws, we've become a source of information for people interested in this subject across the country, provider of technical assistance, and we're actually very active in the improvement of Wyoming's law in this area in 2015. And so I'd like to take this time with you today to walk through the Wyoming DOC law and hopefully demystify any points of confusion that you may have encountered in trying to make sense of how the process of directed outpatient commitment is supposed to work and who exactly it's intended for. So I think it probably makes sense to begin with just a little background on what the thinking was behind the improvement of the DOC law, the creation of the DOC law in 2015. At that time, Wyoming was really in a state of crisis, had a really untenable situation that you were facing with the fact that your state hospital was filled beyond capacity. It's actually the opposite problem that we face in many states where people don't stay for inpatient commitments when they're in psychiatric crisis for long enough. In Wyoming, the problem is that people were staying really too long. The involuntary inpatient population between 2012 and 2015 rose 65% from 208 people to 341. The average length of stays for those individuals was 126 days, which is pretty unheard of around the country. Really, only 75 beds were actually available in the state hospital for a population that large, given that so many of the beds were occupied by people who came in through the forensic system. And so there was this overflow that was being sent to private hospitals, which of course are far more expensive. Bottom line is that the Department of Health's budget to provide for inpatient psychiatric care, two-year budget of $4.4 million was actually exceeded by about $13 million beyond that 4.4. So clearly there was a real fiscal crisis that this was creating for Wyoming. And the solution, which I'm happy to say my organization had a hand in developing, was to really retool the process for outpatient commitment in Wyoming. This was something that existed before, an opportunity to commit people who are a danger to themselves or others, but don't actually need to be in a hospital at this particular time, to allow them to receive treatment in the community, was seen as sort of an obvious part of the solution to the fact that there were just too many people staying in the hospital for too long. And so this process, this legal mechanism existed before but had not been used a whole lot. There was some sense that that it would be worthwhile to retool the process to make it more usable and inviting for county mental health systems. And so that is why we had these changes come into play in 2015, creating this new option of directed outpatient commitment, DOC, and establishing the gatekeeper system, which is really unique to Wyoming, and we'll talk about it a little bit more. But basically, gatekeepers are designated entities for each county that are responsible for determining the appropriate course of treatment for each person who's placed under civil commitment. And there is this terminology issue that I want to address off the bat. You may hear me refer to AOT, assisted outpatient treatment, more than once during this presentation. I'm going to try really hard to use the Wyoming term, DOC, but AOT is what we tend to call this on a more national, universal level. There are lots of different names for it across the states. AOT seems to be the most common, but when I say AOT, we are referring to DOC. So I also think it would be worthwhile to pause before we get into the law specifically and talk about who exactly DOC is intended for. This is not an intervention that is intended for everybody in the public mental health system, for everybody who comes before your court for civil commitment on an inpatient basis. This is very specifically designed for those who we say are caught in the revolving doors of the criminal justice system and the mental health system. Individuals who have great difficulty engaging with treatment in the community on a voluntary basis, and because of the struggle they have, they consequently rack up unbelievable, staggering numbers of hospitalizations in a very short period of time, get arrested again and again, sometimes on minor charges such as trespassing or destroying public property, sometimes more serious cases of assault or threats against people in their lives. But we're talking about individuals who would not be in this situation, who would not be caught on this treadmill if only we could get them to engage in treatment in the community on a consistent basis. And for a variety of reasons, they have great difficulty doing that. One of the main issues behind this problem of treatment non-engagement that some, by no means all, but some people with severe mental illness struggle with is this issue that I don't think gets really spoken about enough, and it doesn't really get enough attention, and it's the problem of anosognosia, which is a symptom of brain dysfunction that is very frequently a corollary of severe mental illness. And basically it means lack of insight, inability to recognize that one has an illness. And I don't want to oversimplify and suggest that's the only reason people have difficulty engaging with treatment, but we have lots of studies that tell us that this is one we really need to focus on if, on a policy level, we want to make a huge impact on this problem. A person who has anosognosia is often mistaken for somebody who's in denial, right? Someone will say, my son is in denial about his mental illness, doesn't want to take his medication. It's important for us to recognize that this is not denial. You know, denial is a universal human defense mechanism. It's something we all practice from time to time when there is some painful truth that we really do know and understand deep down, but we have difficulty in recognizing it and admitting it to ourselves. With the help of a good friend or professional, we might be able to coax it to the surface and face it, confront it, move on with life. That's not what's going on with a person with anosognosia. We're talking very much about dysfunction in the brain, information simply not reaching the brain to where the person, unlike someone in denial, doesn't know the truth deep down. They are certain to their core that they do not have an illness. And once that's understood, I think it lessens the tendency, natural tendency we have to get frustrated with people who are in this predicament, because from their point of view, when they simply cannot see that they have an illness and have a need for treatment, especially when some of these treatments are less than ideal, you know, the medications often have side effects we wish they didn't. When someone can only see the negatives and the hassle of having to follow a treatment regimen and is not in any way seeing the positive or the reason why it's so important that they do this, of course, they're not going to want to engage in it. Of course, it's going to seem like a waste of time and something that's only holding them back. And I think when we recognize this, it really leads us, I think, to this policy idea of DOC and why it plays such an important role in helping to get through to people who are simply not going to get there on their own. And I have a slide here that I think is worth taking a look at just to bring home this point I'm trying to make, that this is about dysfunction of an organ of the body, in this case the brain. Here you are looking at brain scans from two individuals with severe mental illness, with schizophrenia specifically, one who lacks insight and has anosognosia and the other individual who does not. And at this particular moment, you're looking at this brain scan here. The individuals are being asked to perform a self-reflective activity, and you can actually see synapses firing in the brain of the person who has insight that just simply aren't firing in the other individual's brain. And this is no more the individual's fault than any dysfunction of any organ of our bodies that any of us might experience. So nothing within this concept of DOC is about trying to blame or shame the person. We're simply trying to get over a problem that they are not going to be able to solve on their own. And this kind of brings me to my bottom line on anosognosia. Here I like to invoke that corny movie, Field of Dreams, no pun intended. And you remember that line if you've seen it: if you build it, they will come. And sometimes people say that very thing to us about the mental health system, right? That the problem is simply that we have not provided an adequate array of good outpatient services to people. And if we were to simply make outpatient treatment better, people would come flocking into the system. And I don't mean to put myself in direct opposition to that point of view, because I actually do think there are a lot of people who would be doing a lot better if we could simply make outpatient treatment better, do a better job of providing services on demand to those who want it. But I also think we need to recognize that if you build that system, some people that is, people who lack insight, won't come flocking to it simply because they don't understand that that system has anything to offer them. So by all means, let's build that great system of outpatient care. But for folks who are in this predicament I'm describing, let's also do something else. And that's where DOC comes in. This is a strategy to overcome the natural tendency of some individuals to disengage from community-based treatment. This is about a collaboration between you as a court and the clinical treatment system. We are trying to leverage your authority through what we call the black robe effect to inspire an individual who would otherwise be disinclined to engage with treatment to do so simply because he has an idea or she has an idea that the judge has said, I've got to do this. And the idea is not for this to remain a permanent fixture in the person's life, although for some individuals that actually might be necessary because this insight is simply never going to come back. But what we hope to do is through a sufficient period of time where we have this person under outpatient commitment, help them to develop the habits of treatment compliance so that they realize their lives are actually a whole lot better than they had been before. Even if they don't put it all together to the point where they recognize, gee, I guess I had an illness all along. They may not quite get there, but they at least realize that their lives are not in the chaos they were before. And so that is what we are trying to achieve, to help that person get to that point to where they can do this on their own. So let's now take a look at how exactly the law makes that possible in Wyoming. And we'll start with just a general look at the civil commitment criteria in Wyoming. Wyoming is not among the states that have separate civil commitment criteria, one set of criteria for inpatient treatment, another set for outpatient treatment. In Wyoming, if you are defined as someone with a mental illness who is dangerous to yourselves or others, you are subject to civil commitment, and that civil commitment can be on an inpatient basis or an outpatient basis, depending on what is found to be the least restrictive appropriate setting. So we'll start with this definition of what it means to be mentally ill under the Wyoming Civil Commitment Code. And I should say here as an aside, I think it's unfortunate that we are defining mentally ill as being someone who is in need of civil commitment, right? Because mental illness itself, I mean, in the ordinary use of the term, is fixed. It's not about the fact that you are currently in a psychiatric crisis. You can be mentally ill and in psychiatric crisis and need to be under civil commitment. And when that crisis is alleviated and you no longer need to be under civil commitment, in the everyday sense of the term, you are still mentally ill. But that's not how the term is used under Wyoming law. In your state, mentally ill means, and I'm going to quote the law here, a physical, emotional, mental, or behavioral disorder which causes a person to be dangerous to himself or others and which requires treatment, but does not include addiction to alcohol or drugs, except where one or more of those alcohol or drug problems co-occurs as a secondary diagnosis with a mental illness. So when we speak in legal terms in Wyoming about being mentally ill, what we really mean is having a mental illness and currently being a danger to yourself or others. So the key to really understanding what that means is to get to how the law defines that critical phrase, dangerous to himself or others. And that's also spelled out in the law. There are a number of alternative definitions for dangerous to self or others. And most of them are what you would expect. It simply means that a person is likely to commit some act of violence against themselves or someone else, or some act of self-harm, physical self-harm. There is one particular definition of dangerous to self or others that is particularly relevant in the DOC context. So I want to focus in on that, and that's under 2510-101A2 sub C. And there it says that a person is dangerous to himself or others if that individual evidences behavior manifested by recent acts or omissions that due to mental illness, he is unable to satisfy basic needs for nourishment, essential medical care, shelter, or safety, so that a substantial probability exists that death, serious physical injury, serious physical debilitation, serious mental debilitation, destabilization from lack of or refusal to take prescribed psychotropic medications for a diagnosed condition or serious physical disease will imminently ensue unless the individual receives prompt and adequate treatment for this mental illness. I know that's a mouthful. Thanks for sticking through it with me. But you see it, I've highlighted some of the words here in yellow. On this next slide, I am going to just break it down to the words I have highlighted in yellow because they are especially relevant, as I say, to individuals who are appropriate for DOC as the form of civil commitment. And what we're honing in on here is a situation where the individual evidences behavior manifested by recent acts or omissions that due to mental illness, he is unable to satisfy basic needs for essential medical care, so that a substantial probability exists that destabilization from lack of or refusal to take prescribed psychotropic medications for a diagnosed condition will imminently ensue unless the individual receives prompt and adequate treatment for this mental illness. Now, what I would like you to focus on in terms of this specific criterion is that an individual to meet this test need not currently be about to hurt themselves, about to hurt someone else. This is simply about the fact that this individual cannot satisfy their need for medical care, which I think roughly translates to their need for medication, right? They are refusing to accept medical care, and as a result, they are not destabilized necessarily right now to the point where they are in crisis, but that is just around the corner, right? That sort of deterioration to the point of complete debilitation is imminent because of their refusal to follow through with the medical care that they need. Keep in mind the person who that describes, because as we get into this a little further, it's going to be clear as to why that is exactly the allegation that a petitioner should make to you in alleging that an individual is in need of DOC as their form of civil commitment. So the process for obtaining a directed outpatient commitment. The statute says that if the court finds, based upon the recommendation of an examiner or its own determination, that the proposed patient is mentally ill, and again, as we define mentally ill in Wyoming, it means the person is currently a danger to themselves or others, but that individual does not require inpatient hospitalization, the court shall consider issuing a directed outpatient commitment order as an alternative. There are several more considerations you are, as a judge, are asked to take into account when making this determination. The law says that in considering whether DOC is appropriate, the court may consider one or more of the following factors. And as you hear these, I think these really very much define the individual who we spoke of at the beginning, this person who is caught in the revolving door because of their inability to engage with treatment on a voluntary basis. Again, this is not for everybody. This is for a very distinct subset. So the factors are, first of all, of course, that the proposed patient is diagnosed as having a mental illness. Second, that without DOC, the proposed patient is likely to be dangerous to himself or others based on noncompliance, a history of noncompliance with prior medical directives. Third, that the proposed patient is likely to suffer substantial medical or mental deterioration or become seriously disabled. Fourth, that the proposed patient lacks present ability to make an informed decision concerning his need for treatment. I think you can roughly translate that as the person has a lack of insight into their illness. And fifth, that you may take into account any other information concerning the proposed patient's need for outpatient care. All this is based on information that should be presented to you by the party petitioning for a DOC. Another part of the law that I think is worth walking through in granular detail is the provisions that deal with how to enforce a DOC order once you have it in place. Because there is this question that lingers in many judges' mind. Well, what is the teeth here? How exactly is this court order enforceable? And unlike many states, Wyoming is not among the states that take contempt of court off the table. We have a lot of states where the statute actually says that a person shall not be held in contempt of court for violating this particular type of court order. Although that is not the case in Wyoming, I would strongly urge and recommend that you not go there, that you not use contempt as A typical way of enforcing a DOC court order, we're talking about people who have been to jail a lot as a result of their inability to engage with treatment, and we are trying through this process to create a pathway out of jail for these individuals, not to find some creative new way to have them wind up in a jail cell because they have now been held in contempt of court for violating this court order. That really is not what AOT is about, as I think you've probably gathered from the other part of this video where you heard from Judge Kazen. This is really much more about trying to inspire and motivate an individual rather than sort of scare them into submission. And so that sort of leaves a very reasonable question. Well, what then happens? Because we say there should be no punishment attached to violating a DOC, that should not be mistaken for a suggestion that there be no consequence attached to it. And the law actually does a very good job in Wyoming of spelling out exactly what should happen, what that consequence should be when it is clear that a person is not following through with the treatment they've been court ordered to engage with, and good faith efforts have been made to solicit that engagement, and it's just not working. What happens next? So under 2510.110.1 sub G, the law says that a motion may be made to the court by motion of an interested party or on its own motion. The court may revoke or modify the DOC if, after a hearing, the court finds by a preponderance of evidence that the patient violated any condition of the DOC order. If there has been a violation of the order, the court may modify the conditions of DOC, alternatively schedule an involuntary commitment hearing, alternatively to that, order any disposition for which private resources are available or any disposition which is consistent with the best interests of the proposed patient, and public safety. So you have a whole lot of flexibility under the law in exactly how you want to respond to this motion that would be made in this situation for revocation or modification of the DOC court order. There is also a process to make sure that you are provided with the information you need as a judge to rule intelligently on this motion to modify or revoke. The law under sub H goes on to say that if a motion has been filed to modify or revoke the DOC commitment, the court may enter an ex parte order for immediate detention of the patient if the court finds that the patient is a danger to himself or others. We'll talk about that more in a second, but just to continue reading the statute, it says, if the court enters an ex parte order of detention, the matter shall be set for a hearing within 72 hours. So that really lays out the process, right? In order to make an intelligent ruling on whether there is a need to modify or revoke the DOC, you need to have fresh information about the individual's clinical condition. And so the law provides for the person to be evaluated, detained against their will, brought into an evaluation facility, and very shortly thereafter brought into court so that you can have this hearing with this information from the evaluation presented. Now, there is a hump here. For this ex parte order to be granted, you have to find that the person is a danger to himself or others. And I would just like to point out that this is an individual who you have already found is a danger to themselves or others, right? You have already found this person to be someone with a, quote, mental illness as defined in Wyoming law. That is why they are under DOC in the first place. So this should not be seen as a need to find fresh evidence that they're about to hurt someone else or hurt themselves. The fact that they are under a DOC, I think, gives you reason to assume that they are a danger to themselves or others. That's what you found in putting them under a DOC. And now you have a petitioner coming to you to say this person is actually not following through with what you ordered them to do in order to stay safe in the community. So it really stands to reason that you are going to find that this is a person who is a danger to themselves or others currently. The law further explains that a person may be detained when a court has entered an ex parte order for immediate detention. And secondly, immediately after detaining the person, the officer who performs that detainment shall contact an examiner. So we don't just want to detain them so that you can hold the hearing. We want to make sure that they are actually examined during that period of detention. A preliminary examination of the person shall be conducted by an examiner within 24 hours of the detention. The law further directs what the examiner who performs that exam must do, the action they must take based on what they find during the exam. So there are three options here. The first possibility is that they would find, and by the way, this is a law that applies not just to individuals under DOC. These are basically the same three options that are available to anyone, whether under a DOC or not, who is brought in for an emergency exam under Wyoming Civil Commitment Code. The first possibility is that they find that the person is not mentally ill. In that case, the person shall be released immediately. That really is not an option that should be considered possible in the case of a person who's brought in to enforce a DOC that hasn't been followed, right? Because here we're talking about a person who is by definition currently mentally ill. They have been found by a court to be, quote, mentally ill, as that term is defined in the Wyoming Code. And there has been no removal of that finding, and so there is no grounds for the examiner to find this person is not currently, quote unquote, mentally ill. The second possible finding of the examiner is that the person was mentally ill, that is, was dangerous to themselves or others, but now at the point of this examination is no longer dangerous to self or others, in which case the examiner shall, with patient consent, arrange follow-up mental health care and release the individual immediately. Now, theoretically, that is possible, that someone brought in for a motion to revoke or modify a DOC is actually found to not currently be a danger to themselves or others. But if the initial finding, right, if the finding that placed them under DOC in the first place was that they met that criteria C in the definition of danger to self or others that I alluded to earlier and told you before was going to be important, that is, if the person was found to be dangerous to themselves or others specifically because they had an inability to satisfy their need for essential medical care, there should really be no situation where the person is released based on this finding, because you have a patient who was placed under DOC because they had a demonstrated history of difficulty adhering with essential medical care, and now they are subject to this motion to revoke or modify exactly because they are refusing to follow that through with that medical care that you as a court have already determined they need to survive safely in the community. So if the DOC was obtained on that basis, there should be no situation where a person needs to be released when they are examined during their detention because they are no longer a danger to themselves or others. The third possibility is the one that should occur in just about every case of detention on a motion to revoke or modify a DOC, and that is a finding by the examiner that this person is mentally ill, that is a danger to themselves or others currently, in which case the person can be detained for up to 72 hours, which is exactly the period of time you have within which to hold your hearing on what you're going to do about that motion. So all this is to say the law sets it up so that this process should actually work very smoothly and cleanly, where an individual who is thought to be not compliant with their DOC court order is detained, evaluated within 24 hours, and brought into court for a hearing on what to do with their current DOC within 72 hours. Now, there may be a finding at this point that this person actually does not now meet criteria for inpatient hospitalization. They are not in a crisis so acute that they need to be returned to the hospital. Sometimes that may be the finding, but in many, if not most cases, that won't be the finding, in which case the person's released back into the community. So we're not talking about a whole lot of quote-unquote teeth, but it's enough, because what you've done is you've reconnected that person with the treatment team, you've reconnected with them with the court, you've reminded them of the fact that they have this obligation to the court, and you've sent a very clear signal that their adherence to treatment, their engagement is being paid attention to. And unlike what might have been the case before they were under a DOC, where we might have waited around, even though everyone understood this person was back into their old pattern, there might have been a tendency to wait for them to act out in some dramatic way to prove that they are actively dangerous to themselves or others. Here we are going to be much more proactive, and the person gets a sense of that. And through that process, the court order has meaning for the individual in the rare case when it actually has to be enforced that way. I should make very clear, in most situations, you will find it does not come to that. But this is the process that the Wyoming law very clearly allows for the enforcement and the making meaningful a DOC court order. Okay, so in the few minutes that we have remaining, I'd like to just talk a little bit about the other major reform that was made to the law in 2015 under SB 58, and that is the addition of this role of the gatekeeper in the AOT process. And the gatekeeper is very much your partner in making DOC work. Of course, the gatekeeper has more to do than simply monitor people who are under DOC. In fact, in counties that have gatekeepers, there should be a gatekeeper in place for everyone under civil commitment, whether it's inpatient or outpatient. But this person's role is particularly important in the DOC context because the court order is very much a mutual commitment. It's really about committing the system to the patient as much as it is the patient to the system. And that's a point that should be reinforced at the DOC hearing. And that's really where the gatekeeper comes in, to make sure that the mental health treatment system upholds its end of the bargain and is as accountable to the court as the patient is. So just to take a quick look at some of the statutes that relate to the role of gatekeeper in DOC, the law says that the county attorney shall notify the department and any gatekeeper at the point when any DOC is ordered by the court within 24 hours. So if you are in a county where there is a gatekeeper in place and you have issued a DOC order, that information must be transmitted to the gatekeeper within 24 hours. And then the gatekeeper plays a role in the ongoing treatment, essentially working as a liaison between the court and the treatment system. The law says that gatekeepers and other treatment providers may, upon contract or agreement, coordinate and monitor the services and payments required for the treatment of persons with mental illness as provided under this section. Pursuant to contract or agreement, the department may assume any part of the expenses associated with a gatekeeper when expenses would otherwise be the responsibility of a county under this act. So there is, I think, a really strong incentive in the law to use a gatekeeper to oversee the AOT DOC process, because it's going to mean that some of the costs for that are going to be deferred to the state. And in the end, although the gatekeeper itself is really unique to Wyoming, the role that this person plays is very familiar to what we see in AOT programs around the country. This person is essentially functioning as what we call a probate monitor or a court liaison, serving as the single point of contact between those who are responsible for providing treatment day to day and you as a court who have an interest in monitoring the person's progress and how well they are doing. So that is, in a nutshell, a walk through the AOT law in Wyoming. I should also make very clear that there are many parts to making DOC work that are not covered in the law. And my organization, Treatment Advocacy Center, has a lot to offer in terms of helping you negotiate all the various aspects of implementing a DOC program in your county. And we would love to very much work with you and be a part of whatever process you're going through to get that going, get that in place. So I would urge you to please reach out to me. I have my contact information on this last slide. I would like nothing more than to be in contact with you and be a resource to you in establishing DOC within your county and bringing the enormous promise of this law to fruition for you and the people who are coming before your court. So thanks very much for listening to this presentation, and I hope to work with you in the future.